everyone. Okay, we're going to get started. Keep in mind we're on a webcast simultaneously as we go on today, so people all over the state are able to see the program. So when you move about to head out into the hallway or excuse yourself, just keep in mind, just like any courtroom, there'll be extraneous noise that will get filtered into the cast. So try and keep that as quiet as possible. You are free to come and go from the room as needed. And as indicated, there's Chuck got me messed up. There's a drinking fountain and restrooms out to the left and the left down the little hallway. We'd like to start the mock trial kickoff now with words from the St. Louis Bar Foundation. President Judge Stephen Limbaugh and President-elect Paul Venker are going to say a few words to you and welcome on behalf of the St. Louis Bar Association.
Thank you, Rachel. Good afternoon, everybody.
Good afternoon.
I'm sorry we did not use the appropriate decorum here a moment ago because some of us were talking about baseball. Any of you aware of that? What's going on now? All right, that's something more serious. Well, baseball's serious too. I'm Stephen Limbaugh. I am a retired judge in this court. And Paul Venker, in just a moment, will talk to you. Paul is a very knowledgeable and well-recognized litigator and practicing lawyer in this court and in the state courts. We're very happy to have you here under the auspices of the St. Louis Bar Foundation. Paul will say a few words more about the foundation, but the foundation is very pleased to be able to sponsor mock trials like this one because we think it is so advantageous to all of you to be able to participate. Let me say just a couple of words about the system. All of you know from your elementary courses in citizenship and other courses similar to that you've had, that it's very recognized that our country has 3 divisions, which makes it more unique than any other country in the world. We have the legislative branch of the government, which is the president and all of the people who work under him. The executive branch of government, I misspoke. We have the legislative branch, which, as you know, is composed of the Senate, members of the Senate and the House of Representatives and Congress in Washington, D.C. And then the third part is the judicial system. And that's what we're doing here today, to talk about the judicial system. There's a lot of controversy today about the importance of each of the 3 branches. Some think that the president has too much power. Some think that Congress has too much power. Congress can pass a law, and it becomes a law unless the president vetoes it. And the president can veto it. In other words, the law is no longer a law. Congress can override the president's veto by a 2/3 majority. So that's a good check and balance that those 2 groups have to prevent one from being all-powerful. The judicial system has this check. The judicial system has the right to determine that a law that Congress has passed is unconstitutional. That is, it does not meet the standards required of our Constitution. So even though the law may have been passed by Congress, if the judges in the judicial system and our Supreme Court determine that the law doesn't meet constitutional requirements, then it is no longer a law. So all 3 of these groups have the right to have certain restrictions on each other. Now you're here today as a part of the judicial system. It's very interesting that when the judge comes in on the chair back there, everybody stands. The marshal will make certain everybody stands. Now, of course, everybody recognizes the judge and his importance. But you stand not because of the judge, you stand because of the place. This place, the courtroom. This is the place where justice is meted out. It's done through lawyers, through the judge, through juries who sit over there, and then through the entire system that makes it all work. You, as young people in high school, are having an interesting opportunity here to see some of these fine lawyers show you how a trial is going to be conducted using everything we have here. The jury box, the judge up here, where the lawyers stand here, where the witness will sit, in the witness box over there, or where the court reporter will sit, and they will tell you about these things and how they are instrumental in the trial of the case. This is so important for you, and you have a good opportunity, again under the auspices of the Bar Foundation, to participate in this kind of proceeding. It does a lot for you. First of all, it will acquaint you with how this works. Second, it will show you how the various court personnel operate. And it will enable you to participate yourselves. There's nothing like getting before a group of people and trying to eliminate that little stage fright you may have in doing that, and talking to somebody, with or without notes. There's nothing better than that. And here you're going to have this exposure to see how this court system works. Everybody, this system is not perfect. It's not a panacea, but it is so much better than the other countries of this world have. And we need to uphold it. You're going to learn about it today, and it will help you in farming what you're going to do in your own careers. We welcome you very much, and we hope you come away with this with a lot of knowledge and understanding. All right, Paul, thank you.
Thank you, Judge. Good afternoon, everybody. As Judge Limbaugh said, my name is Paul Venker. I'm the president-elect of the Bar Foundation, so in the future, I'll have Judge Limbaugh's position. I just want to add a few words about the foundation and the foundation's mission, because the foundation is a principal mover and shaker for this project with Bar Association of Metropolitan St. Louis. And what the foundation is really about is a phrase you may have heard before, but maybe not. It's really called the rule of law. And the rule of law is really a simple but very overarching concept for a society like ours, where basically that society agrees to set up certain rules. You may think of them as statutes, regulations, whatever it is, that everyone agrees to abide by. And so what you see here in the justice system is the focal point of where the people who aren't abiding by those and the people who want them to abide by those rules meet. And that's how things get worked out in a society like ours. And so the thing to think about for you is, as the judge referred to and said, jury trials and our system is pretty unique and pretty valuable. I don't know what you see in current programming, Game of Thrones, or whatever you may see, these historical events where people are doing trial by champion, right? They have their two best fighters get together and they fight the fight, and then everybody goes with whatever the outcome is. Okay, you've heard of the Salem witch trials probably. All those things. How about the duel in Romeo and Juliet, where the family have a blood feud, and so they go after each other. Not doing it in the court of law, right? And the prince is not happy with them, but that's what they did. And that's what people would do if something like a jury system were not here, if there were no courts to enforce these laws that people have agreed to. And so you have an opportunity, hopefully, something that will stick with you to engage in critical thinking. That's really what it is. Like I said, you all heard about the Salem witch trials and how witches were tried, and if they sang, they were innocent, and if they floated, they were a witch. Wow, what kind of a deal is that? If you sing, obviously you're dead. And so that kind of logic at the time was thought to be a fair approach to the process. Okay, and so what you're seeing now is obviously an evolution in that critical thinking, and you'll exercise that as you go through this process. And so hope that it sticks with you and that you do appreciate you got some great instructors both here and you will throughout the program, I'm sure. People who want to impart to you that knowledge and help you think on your own, because that's what you're all going to have to do eventually, is think on your own, not just about legal issues, but just life in general. And that critical thinking will carry over for you in those other areas, no question about it. One thing I did want to mention is the Bar Foundation is a foundation, which means it doesn't have a lot of money or funds. It relies on contributions. So if you or your parents can see, if you go to the foundation website, it's just stlouisbarfoundation.org. You can make contributions there, and I would encourage you to think about even a small amount. None of the instructors that will be in this are paid at all. They're doing this out of volunteer time, but it still costs money to get all these things together, all the video equipment, rent the spaces that are needed, get the materials printed, and all those things that help. So even the littlest amount of thinking about the foundation in that way would really be appreciated. Anyway, congrats on being involved in this, and good luck to you all. Thank you.
Thank you, Judge, and thank you, Paul, very much. I believe also that if you give to the Bar Foundation, am I correct that it can also be designated giving?
Yes, it can be.
So if you're interested in just giving, particularly for the use of the mock trial fund, your parents, your family, you can designate those gifts accordingly. All right, so now let's talk about mock trial overall. As I indicated, my name is Susan Ward. With Mark Hartford and myself, we have worked for several years from the Bar Association side as the lawyer liaisons with the Bar Association and the Bar Foundation in terms of putting on both the state competition many years and with handling the St. Louis side of the program. Steve Campbell is at the Bar Association. He runs it in terms of all the administrative, and there are people that help him. Rebecca Nicholson is essentially our rules guru in terms of putting the program together. She reviews the problem. Thanks to Randy Pierce, who's back with us, who's also on our committee. There is a mock trial committee that if you are interested as a teacher or a coach in participating in, we love to have your input. We don't sit around and meet frequently. We meet as needed. We make changes as needed, and typically those are after a season of what we like to call constructive criticism. So we'll sit down and look at different things. So we would like to have anyone's involvement, and for those of you watching this on the webcast, also have your involvement by simply calling into Steve Campbell at the Bar Association. We do want to thank the Bar Foundation very much for their support of the program, because without those funds and without the giving that goes through the Bar Foundation, this program would have difficulty, even though it's not the most expensive program that we do. It is one of the most, in my mind, community beneficial and service-oriented programs that we have. Now, one of the things that we've done this year through the mock trial program is we have condensed the program statewide from what used to be 4 regions into 3 regions. And this is important for those of you who are from not St. Louis, because the issue that we have encountered through the program is that on the east side of the state, there are significantly more teams than there are on the west side and mid-state and outstate in terms of what the competition looks like. And for those of you who have been at state and have coached before and have taught before, state is comprised of typically 8 St. Louis teams, which is half the teams that go to state. And then the other schools come in by region in the number of participating pro rata share, sort of thing. What we are looking at this year with 3 regions is 3 regions. One is the St. Louis region, one is the Kansas City region, and then the other is called the outstate region. And in that outstate region, that's going to include everyone else, specifically Columbia, Jeff City, Springfield, and other schools then that will join in. In the past, we've had homeschool teams compete. When we were in Columbia for state, we had a homeschool team one year. The purpose of condensing the regions is actually to grow the program. And what we have done in terms of a program is put ourselves on a 3-year growth pattern. And in the event that the program cannot be grown in terms of outstate or Kansas City side in numbers of teams that can then change the division at state, we are going to have to condense state. We are not going to send 16 teams to state. And the goal is that over the next 3 years, we will add teams from all over Missouri in order to keep state the size that it is, which is 16 teams getting to go that are not dominated by one side of the state or the other, so that the share of teams at state is more equal or equitable in terms of participation. So we would ask that everyone consider this a positive move on the part of the Bar Association, the Bar Foundation, and the mock trial program, because we have lots and lots of mid-state and out-state interest. It is very challenging to put together the time and energy, the funding, the buses, the after-school programs that some of you here in town, particularly in St. Louis and Kansas City with large school districts, enjoy as a matter almost of right, because your school districts can afford to do it and they can include it in their programming. So it's a significant change because it has a significant plan behind it in terms of actually trying to grow the program by reducing the regions. So that's what we're looking for long term. As far as dates go, the important dates for everyone to know have been sent out to you, but just to review them, all team registrations are due December 6th. So keep that in mind for the number of teams you're putting in, whether it be 1 team or 10 teams, those are all due by 5 o'clock on December 6th. Keep in mind, there are no exceptions to this deadline. No applications will be accepted after the 5 p.m. December 6th deadline. So be sure and note that for your attorneys or coaches, teachers who may or may not be here. Then for all of you students, given our busy schedules, given sports, given lessons, given all kinds of other activities that those of you who also participate in this program engage in, you need to put down the nights of the rounds. And you need to keep those on your personal calendars. And the reason I say this is because your teachers and your coaches cannot do this for you. You guys are in high school. You have to control your calendar in terms of planning. So round 1 is January 28th and 30, which it's always a Tuesday, Thursday, here in Missouri on this side of the state, or in the St. Louis side. And then round 2 is February 25 and 27. They always start at 6, they always go till about 8:30, and you always need to give yourself advance notice and give your other teams, your other practices, your other coaches, your other leaders information so that you don't short your team on those nights. Because again, it's a team effort. You miss a witness, you miss a lawyer, you've got all kinds of a shakeup. So it is important for you students and everyone watching to put those dates on the calendar for the St. Louis competition and be sure that you plan ahead. Don't suddenly realize that you have whatever dance or whatever test or whatever ACT, I don't have children old enough yet. But just keep in mind that this is something you have to plan for as well. The regionals will be March 11 and 13. So for those of you who advance to regionals, it will be March 11 and 13. March, busy, spring break, busy time, lots of things going on. So be sure and write that down as well. And then state will be at the end of March, which is the 28th and the 30th, and it will be
either here or Columbia.
Either here or Columbia, in St. Louis or Columbia for state this year. So that's a little bit of planning that everyone can do, at least sort of planning. The other things that that we like to point out about mock trial is the program's mission is to be able to reach out to the community, to be able to reach out all over the state to high schools, to families and students and teachers, and to educate them on the law and the process of law, just like Judge Limbaugh was talking about. It's so important to understand what our country offers by way of our democratic, our judicial system and the way that our country is set up in terms of the judiciary and the process. And from the day you get your first speeding ticket, and don't act shocked that I know this happens, from the day you get your first speeding ticket or your first, little infraction, you need to know what the process is. And this is to educate you on the process. It's to make you comfortable with the process. It's also to provide, the purpose of this program is also to help you personally with personal growth. It's not whether you win your particular trial that night or whether you're going to become, as in this year, whether you're going to become a certain kind of civil lawyer or criminal lawyer or any kind of particular area of law. You may not be a lawyer at all. You may find that when you get finished with high school that you really don't have any desire to do something pre-law in college. Or you could be like me, who had no idea that she was going to be a lawyer or go to law school and decide that her senior year of college. Not your best move. Let me just say that's really not the best road map to go with. But what this does in this program, it's going to help you with the everyday things that you have to do. Just like I'm talking to you about get control of your calendar, get control of your dates. This program is going to help you with organization. It's going to help you with logical thought. It's going to help you with critical thinking, critical reading, and ascertaining facts and circumstances, and how to make those work to your advantage. It's also going to help you with thinking on your feet. Because when you're getting into a cross-examination situation, whether you're the witness or whether you're the lawyer or you're the defending lawyer, you need to be thinking on your feet about what happens. This is certainly a canned program, as they say. Everything you want to know is in this 58 pages that came out, plus the few more pages that are going to come out in terms of exhibits. It's all there. There isn't going to be, too much that we can move off the problem. But you still need to be prepared for how any one lawyer, any one team, or any one witness is going to respond to you, and how are you going to respond back. The other thing that this will do for you is it will allow you to stand up in front of a group anytime, anywhere, and hopefully not go completely mute. Okay? It's important to be able to say, hello, how are you? My name is Susan Ward, and shake somebody's hand. And to do it with poise and to do it with confidence. It's important to stand up and when your shoe breaks or your hair goes crazy or you lose a contact, to handle that with poise. And that sounds silly as we sit here today. That stuff happens. It happens. I can tell you more than once that a shoe, I've been walking on my toe on one foot while my other shoe remains intact. It's not fun. But given the fact that I've done this so many times, I've stood up in front of so many people and in so many courtrooms and so many social groups, it's just a broken shoe. That's where we want you guys to get. We want you to walk into a job interview, whether you're interviewing at Hardee's or whether you're interviewing at a university. We want you to be able to say who you are, what you want, why you want it, and why you deserve it. And why it's important for you to be their employee or their candidate or their scholarship candidate. And these are the kinds of things you will gain through this program. So the most important thing to talk to those of you who are new teams is don't get discouraged by a critical score or a critical review or a loss. These are the types of things you handle all the time. You're not going to get that scholarship, you're not going to get that job, you're not going to get that car you want, or you didn't make the great argument to get yourself out of trouble. All kinds of things. These are the things you get better at with the adversity of just the competition itself. You're going to get better at everything else. You're going to be more poised at everything else. Now there's also some very, very practical opportunities that come from specifically the mock trial program. My favorite one is scholarships. This is a hot ticket for college anymore, a very hot ticket. And as recently as 2 years ago, we had a $10,000 scholarship winner to a college because of mock trial. She got 10 grand to go to the school of her ultimate choice just because of her mock trial experience. Not because they won state, not because they did anything that they looked at right at the end of the competition, but because she had participated. So there's very practical ramifications, and like I also talked about, jobs, all kinds of opportunities because you have been in this program, because you have the skills that I just talked about. So what I would tell you in terms of this program and its overview is take hold of this opportunity. Whether you are a freshman or a sophomore or a junior or a senior getting ready to flee high school, take hold of this opportunity. Thank your teachers, thank your coaches, thank your parents for giving you the opportunity, and bust it in this competition. If you're doing it because you have to, then put the best that you can into the program. Maybe your parents said you have to do this because of something, or someone else says you have to get this credit, or your school mandates something. But you know what? Give it everything you've got, because maybe you turn out to be the best kid in the school, or the best school in the state. So to take the opportunity and make what you will of it is something that every one of you can do, whether you are a brand new team or whether you're a team with 3 or 4 years experience as a team. So use the knowledge, channel it into productivity, no matter what area of life that it is. Like I said, you don't have to be lawyers, it's expensive. To go to law school is very expensive. It is very time consuming. It's 3 more years of your life after college where you can be working and earning money. But there's a lot of other things you can do with the experience that you gain here if you choose not to go to law school. So this is it's gonna turn out great. We can't wait to have the program. I've been doing it for probably as long as you guys are old now, which is so sad to say. But I look forward to my kids doing it at some point, and so we welcome you. And what we're gonna do next is to get you ready with the rules. There are some changes, and Rebecca Nicholson is gonna go through the rules with you. Right, am I right?
You're close.
Thank you, Susan. I will start off by inadvertently correcting her. There are no changes this year to the rules. Yay! I'm Rebecca Nicholson, and I've been doing my trial, not as long as Susan, thank goodness, but close. And I would point out that both Susan and I were taught by the retired Randy Pierce, who was in the room today, so welcome back. So who brought a copy of the rules? It's online. Guess what? No one ever brings a copy of the rules but me. I won't go through them in as much detail as I have in the past, one, because there aren't enough copies here for you all, but I will tell you that you will want to read these rules and you will want to understand as you go through the case how the rules can apply to the case. And I can tell you that the esteemed author we have here knows these rules as well, and he used them in developing some of the issues in the case. And so the rules are going to help you figure out what those issues are, and they're going to help you develop a strategy as you go through the case. So I'm going to quickly just go through some of them because I think that they're important for you to look at as you read the case, to the extent that you might even want to glance at the rules before you read the case, because it'll give you some tips. You'll know instantly when you read it, oh, this is an issue because I remember it from the rules. So, how many people have done my trial before? All right, so about half in the room. So, as you know, when you get the case, it's got some witness statements in it. The witnesses are going to be bound by those statements to the extent that they are going to create the story that you all are trying to show in the courtroom. However, some of the facts have been left out because no case includes all the facts. So you're going to find out that by reading the rules that you're allowed to do what we call extrapolate, which means you're allowed to add facts that fall in line with the case. And there's a specific rule on this, imagine that. So you want to make sure that you are being in character as a witness and that you want to make sure that what you're saying falls in line with your statement and in what falls in line with the case. Otherwise, there's an objection for that, and there's a way that the attorneys can get out of that, and there's rules for that as well. There's rules on witnesses, unfair extrapolation, how many attorneys you can have. You can have 3 attorneys, you can have 4 attorneys, and how all those roles fall into play, how redirect and recross work, and your coaches will talk to you about the strategy of using redirect and recross for your specific witness and for your case as a whole. And I think it's important that you recognize sometimes the advantage and the disadvantage of using redirect and recross, again, in the rules. So now you're thinking, darn, I really wish I would have brought those rules. Maybe next year. So there's also information in here about openings and closing arguments, which of course are essential to the case, and the time limits for those. One of the big rules that we always get questions about every year is, can I talk to my timekeeper? Can I talk to my coach out in the hall? Who am I allowed to talk to? The team is allowed to talk to the team, and no one else is allowed to talk to the team. Does that make sense? So even the timekeeper cannot talk to the team unless it's about a timekeeping issue, and you want to make sure you're doing that in front of everybody and you're not trying to do it in the hall. We really want to make sure that the team is doing their own work and that, you know what, us coaches, we've done all we can do. Once the trial starts, we're out of there. There's nothing else we can do. So There are several rules on that because we've had issues in the past, and we just want to make sure that nobody gets disqualified or gets any points taken off for inadvertently talking to someone. So make sure you read that rule and that you understand it, because we don't want anybody, we want everybody to come in and do their best and win fair and square. So another key issue that's in the rules is that students may read other cases and materials in preparation for mock trial, but the teams may only refer to the materials in the trial packet. So as Susan said, you're going to get these 58 pages plus exhibits. You can read more than that. You just can't quote it in the courtroom. So there are some issues, for instance, in this case on medical bills. I'm going to suggest that you go look up some other case law on medical bills, because let me tell you, it's a hot topic here in Missouri. And good luck finding the most recent case, because it changes about every other week. So make sure that you, but some of the strategy that you might find for your case, you might find another case law, you just can't quote that case law. But you can use the strategy and use it to develop your own strategy. So keep in mind that there are other ways you can research besides just reading these rules and reading the case. Exhibits, you get to use enlargements. You can enlarge up to 2 exhibits, and a lot of schools do, a lot of schools don't. I'm not sure it's ever really had an impact on who wins or loses, but I think it helps you direct your energy towards the exhibit rather than always direct it at yourself. So sometimes it's helpful. These are all jury trials. So the evaluators are going to sit in the jury box. When you're doing your mock trial, you're going to speak to them as though they're the jury. And then you'll have a presiding judge who will also be scoring you sometimes, and sometimes will just be giving whether the plaintiff or the defendant did a better job. You'll have that person sitting up at the judge's bench and ruling on objections for you. So, and that's really the biggest issue that we have when it comes to the rules, is the objections. So in your packet that you'll find online, you will also see a modified federal rules of evidence. Who brought that with them? These are very similar to the rules of evidence that are used in this very courtroom. They've been modified slightly, and these are the rules that are used by the National Mock Trial Competition. So by using these rules, you are getting ready to go to nationals. So you want to look through some of these rules, and I'm going to point out a few to you, although I might get some feedback from over here, but some of these rules were clearly thought about in the writing of this case. And you want to go through and think about them too. And I'm not so sure they're going to come out really clean when you guys are trying this case. And I think that's probably on purpose. But you want to think about how these rules play into your case. So if you brought them, you'll want to turn to Rule 407, which is subsequent remedial measures. Now normally you can't ever have any testimony about subsequent remedial measures. But it talks about when you can and how you do it. So you want to read that rule, because I think it's definitely going to impact how you handle this case. Rule 602 is used in a lot of cases, and that's the need for personal knowledge. You know, you can't talk about something that you don't have personal knowledge of, that you think someone did, or that someone else may have done, that you know. We all talk about knowing something, but really, how do we know anything? Well, most of the time we don't. And so you want to look at these witness statements and look at how this person knows what they're testifying about. And if they lack personal knowledge, you're going to want to look at Rule 602. And if they know it because someone told them, you're going to want to look at the hearsay rule, which is every lawyer's favorite rule. And that starts at 801, and it goes for pages and pages and pages. I'll let you know that there are exceptions to the hearsay rule that are definitely going to come into play during this case, and how well you argue it, those rules can make or break this case for you. That's just my personal quick opinion from reading it. But so there's 2 sets of rules. There's the local rules, and then there's the federal rules of evidence that you get. Both are on the BAMSA website, by the way. Easy to access. The local rules are basically, you know, how we run things, and then the federal rules help you object and help you make sure that both you and the other team are following the rules. Let me tell you that as lawyers, we know that this is a rule-based system. So When you are objecting in a trial and you can quote the rule number and the rule to us and make that a very easy decision for us to either sustain the objection or overrule the objection, you have made a judge's life really easy. You're going to find, if you go into the law, that judges don't like ruling on controversial arguments. They want you to make their job easier. So by doing that, by citing the rule number, by citing the rule, you are going to find that you're going to be more successful in your arguments, because the judge is going to go, yep, they're right on that.